Hello, everybody. This is Amy Schwartz-Wallace from the Empire Justice Center. We have over 100 people registered for today's webinar, so we are opening up the lines a little bit early to get them all set up so that we can start promptly in 1 minute. While you're waiting, if you take a look at the handouts bar, you'll see that there are 4 handouts for today's webinar. One includes the attorney affirmation form, city and state cybersexual abuse training materials, the manual from May 2019, and a copy of the statute. So please, those are available during today's webinar. So please save those to your computer, print them, do what you like with them because they will only be available during today's presentation. All right. So welcome to today's webinar. It's entitled Fighting Cybersexual Abuse, Safety Tips, Litigation Strategies, and New State Legislation. We're so excited to be joined today by Lindsay Song and Nicole Fiddler, who are both with Sanctuary for Families. And Lindsay and Nicole were both advocates as well as authors or co-authors of the legislation that we're going to be talking about today. So they're very well placed to share with you the information. Because we have so many folks who are on today's webinar today, everyone is in listen-only mode. However, we recognize that there's going to be questions that folks are going to want to be able to ask. We will be entertaining all questions today at the end of the presentation. And you can simply ask a question by going to the Questions tab and typing in your question, and then we will be taking them. It's possible that the question may be answered, but we'll try to move through them as quickly as we can. Again, for folks that have just joined us, today's webinar includes 4 different handouts, and those are available during the presentation only, and they are posted in the handout section, and you can pull those down and save them. They're all in Adobe PDF format. So without further ado, I will invite Lindsay and Nicole to begin the presentation. Thank you.
Great. Well, thank you all for being here today. We're going to go through the issue of cybersexual abuse, the new state law that was recently passed, and in fact, just went into effect this past Saturday, September 21st, so this webinar is rather well timed, and we'll also discuss some safety tips and takedown remedies, and we'll have a little bit of time at the end for some questions. So we'll just go ahead and get started. For those of you who are not familiar with the term cybersexual abuse, it typically is colloquially referred to as revenge porn. You'll also hear it referred to as non-consensual pornography, or NCP, sometimes e-sexual exploitation, but really what we're talking about is the dissemination or threat of dissemination of nude or sexually explicit images or video without the victim's consent. However, this can include what is right here, someone takes a photo of someone else, or maybe perhaps the victim takes a selfie and sends it to their partner, in the course of a romantic relationship when things were good. It could also be the faking of images, however. We see a lot of images that are not, in fact, true images of the victim, but are what we call spoofed images or photoshopped images. There's also kind of this very disturbing trend towards what are referred to as deep fake videos, which are really kind of expertly photoshopped fake videos that really look very realistic. And so it's actually quite easy to take a photograph and really make it look like it is of the victim when it's really not. Or it could be something as simple as posting a naked photo of someone that's not of the victim, but perhaps has the same body shape or size or some other distinguishing characteristics, and then saying that it is the victim, which can really be just as damaging as if it were the victim. And of course, it's difficult for people to say, no, that's not in fact my naked body, so it can really be just as damaging. Cyber abuse really is a much broader category of things, which also include using the internet and other technology to harass and intimidate victims, such as posting their personal information online without their consent and encouraging others to come to their home or place of business to seek sex or to hurt them. That's often referred to as doxing. But there's kind of a broad category of behavior that we're talking about when we talk about cybersexual abuse and abuse. But today we're really going to focus on the dissemination or threat of dissemination of these sexually explicit photos or videos. Cybersexual abuse is a form of gender-based violence. As you'll see from the statistics on the screen, which actually mirror, there's a 2016 study that also showed similar rates. The vast majority of victims of cybersexual abuse are female, and in fact, a huge majority suffered, in one study, severe emotional distress due to the abuse, over 93%, which is something that we definitely see mimicked in our cases. Many were also harassed or stalked outside of the internet by users that saw the material online. And in fact, in this study, over half contemplated suicide. And in fact, there's been a couple of high-profile, actual completed suicides, that of Tiziana Cantone, who was an Italian woman whose sex tape went viral, and she committed suicide shortly thereafter. And from the cases that Nicole and I have seen, as well as cases that I could speak to of colleagues at Sanctuary, but also other organizations that we work with closely, this is really a common trend, that the vast majority of victims of cybersexual abuse, it's truly can be life-ruining. People can really be affected on a number of ways, which I'll talk about in the next couple of slides. One important note as well is that there's a disproportionate effect on those in the LGBTQ community. Those who are LGBTQ are actually 4 times more likely to be victims of cybersexual abuse than those who are heterosexual. So really something to pay attention to as well. And there are particular vulnerabilities for those in that community with, with outing or with perhaps different statuses that are not known to a victim's family or friends. So really important to note here that those in the LGBTQ community are also incredibly over-affected by this type of crime. Just to give you an overview of a couple of case examples and kind of the stories that we see, these are true case examples and ones that we see that are quite similar as well. In the first client profile A, this is actually a client of mine. My client's physically abusive husband threatened her that if she ever left him, he would send damaging photos of her to her coworkers, family, and friends, and that if she ever filed for custody or divorce, that she would lose custody because the judge would see her as an unfit mother due to these photos. When she finally was able to flee her abuser, he posted several naked pictures of her across social media. He actually broke into one of her social media accounts, and she currently still is worried that future employers or her own children will see these images, and said, I hope that issues like these are taken more seriously because it leaves us feeling defeated. And in that case, the abuser actually did bring the naked photos into court, and his attorney had them printed out and, in fact, waved them around the courtroom to show to the judge, that she was so slutty that she was posting these images across social media. Luckily, in that case, we were able to get an order, which we'll talk about later, prohibiting the abuser from disseminating those photos, and it stopped, but the damage, was partially already done. Another example, we had a client who used physical violence and threats to force the client to take naked videos of herself. He then posted these videos to social media, and they went viral, in fact, spread internationally. And the client was forced to flee New York and start a brand new life in another state. And in fact, she and her child both had to change their names because they were still recognized by the videos because they were so mainstream. And finally, another example, we had a client whose ex-boyfriend photoshopped her face onto naked images he found online and sent these images back to her family, who was from a different country, a more conservative village that she was from. And her father legally disowned her, cut her off from her inheritance, and further had her rely on her abuser, and she actually attempted suicide. So these are 3 case examples, but we see honestly hundreds of folks coming through from Sanctuary and others who experience very similar forms of cybersexual abuse to these, but these are just kind of 3 examples. And finally, cybersexual abuse is a form of power and control. I imagine many of you in the audience are familiar with the power and control wheel, but we see a number of forms of power and control being utilized through cybersexual abuse. One is coercion and threats. Threats to disseminate these images and videos can be just as terrifying, in fact, and really can be used to control victims of, if you don't get back together with me, then I'm going to send this to your job and get you fired, or I'm going to show our kids these photos, or I'm just going to post them all over social media. Emotional abuse, used to shame or humiliate victims, make them feel guilty for taking photos, that they took them willingly, or in fact, look, maybe perhaps even a videotape of a sexual assault. We've also seen that happen as well. Using children, threaten to send the photos to a children or to undermine the relationship with the children. And finally, economic abuse. We have seen repeated instances of clients being fired from their jobs, or their professional reputations have been at risk because these photos have been posted online, have been used to, even edit their professional work pages, or try to slander their names so they're not able to get jobs. And we've actually had a number of clients who have been fired because these images were used and effectively used in order to cut them off from economic aspects.
Hi, everyone. This is Nicole Fiedler. I'm the Pro Bono Director at Sanctuary for Families. I'm now going to take us into getting into sort of the nitty-gritty of the new state law. Up until very recently, New York was actually one of only 5 states in the country that did not have a law directly addressing the cybersexual abuse that Lindsay's been talking about. There had been a bill proposed for a number of years, but it wasn't until this year on February 28th, when the New York Assembly and Senate unanimously passed the legislation that now provides both criminal and civil relief to victims of cybersexual abuse. And you can see here the press conference. These are the 2 lead sponsors of the bill, Assemblyman Ed Bronstein and Senator Monica Martinez. So the governor then signed the law on July 23rd, and its provisions actually just became effective on September 21st, 2019, so just this past weekend. This is sort of an overview of the main things that the law does, but then we're going to get into it a little bit more on the following slides. So sort of the 3 main things the law does. First, it creates the crime of unlawful dissemination or publication of an intimate image, which I'll probably shorten throughout the presentation to just unlawful dissemination. Second, it creates a family offense of unlawful dissemination or publication of an intimate image. Third major thing, it creates a private right of action for individuals to pursue injunctive relief and damages from perpetrators who disseminate their pictures. And finally, it also allows for an action or a special proceeding that would let a victim obtain a court order that would instruct a website to remove an image or video. And that's sort of the broad overview. I'll get a little bit into each of those now. So first, with respect to the criminal penalty that it creates, the new criminal offense is found at Penal Law Section 245-15. It's a Class A misdemeanor, which means that it's punishable by up to a year in prison or 3 years probation. So generally what it does is it makes it a crime to share someone else's naked or sexual images without their consent. But as you can imagine, there was a lot of back and forth on the actual language and what the elements of that crime would be. So we've broken down the elements a little bit here. First, of course, there's an intent element. Again, this was something that was debated and we went back and forth on, but ultimately the intent element is the intent to cause the emotional, financial, or physical, the intent to cause harm to the emotional, financial, or physical welfare of the victim. Then there's the content of the image or video. And just to be clear, this law does cover both still images as well as videos. So then there's the content. So the image or video that has been disseminated must depict either the unclothed or exposed intimate parts of the victim, or it must depict the victim engaging in some sort of sexual conduct. So it's important to note that if the image falls into the latter category, it's not necessarily a requirement that intimate parts be exposed if the victim is engaging in some sort of sexual conduct. Note that if the image falls, the second point, the victim must be identifiable in the image and or the video, and that doesn't necessarily, again, mean that a person's face must be in the image, but it does mean that there must be some way to connect the person in the image to the complaining victim. So then there's the consent element, and that involves the fact that the image of the video was disseminated without the victim's consent. And just so that it's totally clear, even if the victim consented to taking the image in the first place. So, for example, they're in a relationship with someone, both parties consent that they'd like to trade, intimate pictures of one another. That consent is not what counts here for purposes of this law. It's whether the images were disseminated without the victim's consent. Finally, there's an expectation of privacy requirement. So the victim must have had a reasonable expectation of privacy, and the perpetrator must have known or reasonably should have known that the victim intended for that image or video to remain private. So there are some exceptions. I think some of them are fairly common sense. So the reporting of unlawful conduct, so that someone can actually go and show these images to the NYPD or whoever they're reporting to, and showing that image to that third party in order to report it would obviously not fall under this crime. Dissemination or publication of the image made during lawful and common practices of law enforcement, legal proceedings, or medical treatment. And then finally, images involving voluntary, and that's important, voluntary exposure in a public or commercial setting. And then, of course, dissemination of an image made for a legitimate public purpose. Okay, so then the second big piece of the law is the civil relief that it creates, and there's sort of two main points there. First, it amends Article 8 of the Family Court Act, so that unlawful dissemination is included in the list of family offenses. That amendment was actually not included in the original draft of the bill when it was first introduced a few years ago. Luckily, when we raised it with Assemblyman Bronstein, he said it was a no-brainer, and so they added the amendment to the bill pretty quickly, which I think was really important for people who are representing victims in family court. And Lindsay will talk about this a little later, but this will make it easier for people to obtain civil orders of protection for this sort of behavior in family court. So we thought that was a really important piece. And then finally, it amends the New York civil rights law to do two things. First, create a new private right of action where a victim can bring a cause of action if there's been dissemination or, and this is important, I think, if there's been the threat to disseminate or publish. That is the one big distinction between the criminal and the civil piece. Threats are not included in the criminal penalty. It was discussed and ultimately rejected in the final draft of the bill. So threats are not included in the criminal penalty. They are, however, included in the civil cause of action, which we think is important because, as Lindsay said, a lot of times abusers will use these pictures to threaten and coerce our clients into doing things they wouldn't otherwise do. So the victim can sue the perpetrator for injunctive relief, punitive and compensatory damages, as well as costs and attorney's fees. And the same exceptions that I went over in the criminal penalty will also apply here as well. The other thing that it does, the other piece of the New York Civil Rights Law that it amends is it creates the private right of action, and it also creates an action for victims to obtain an order that would require a website to permanently remove an image if the image is within the website's control. Now, important to note that this does not allow you to seek damages from the website. Websites are generally immune from liability under a federal law called the Communications Decency Act. So this provision only allows for injunctive relief to try to get the image down if the website will not take the image down voluntarily. So this is one of the first provisions of its type in the country. So it hasn't been tested yet, as far as we know. It does have the power, I think, to be the potential to be a powerful tool to help victims, where the websites won't voluntarily remove the images themselves after you've requested them to. I do say potential just because I think that the first case to seek this sort of injunctive relief from a website will probably face some challenges, including First Amendment challenges, as well as challenges, claiming that the website has immunity under that federal law I mentioned earlier, the Communications Decency Act. So I think it remains to be seen how this plays out. We're hopeful that it will be helpful for victims and survivors, but it's definitely a provision that we'll be keeping an eye on as the law gets implemented. So we're hoping that this law provides a great avenue of relief for victims. We just wanted to note that there are some other criminal offenses that this behavior might fit into. And, especially because this is a relatively new law and people are still learning about it, law enforcement is still sort of learning about it and grappling with it, I do think it's important to sort of be creative in how you're fitting this behavior into the different penal offenses. And so some sections you might look to, in addition to this new state law, are offenses against the right to privacy, like, for example, unlawful surveillance, dissemination of an unlawful surveillance image, tampering with private communications. Of course, there's also harassment, coercion, stalking, witness tampering. So witness tampering could be a situation where maybe the perpetrator is threatening your client that if they do not withdraw testimony or change testimony, they will release these intimate images. So witness tampering might be another sort of creative way to address this type of behavior. All right, so that's sort of, and then the last thing we do want to mention with respect to thinking about other criminal offenses is that prior to the state law being passed, there were a number of local laws that were passed. So, for example, at the end of 2017, the New York City Council passed a bill that created the crime of unlawful disclosure of an intimate image and also created a civil cause of action. So it's a bill sort of similar to the state bill that we just talked about. And I do know that other counties in New York have done the same, like Nassau and Suffolk. I'm sure others have as well that I just don't know about. But so looking to local laws can also be helpful when thinking about how to put this offense into this behavior into a different offense. So I think that's it for the criminal piece, although of course we'll take questions on that at the end. I'm going to turn it over to Lindsay now to talk about sort of the application in the course.
Great. So for those of you on the call, I believe looking at the participant list that many of you practice in family Supreme Criminal Court, so I'm going to focus on the court's roles and what you can do as an attorney in order to address these types of abuses happening in the middle of these cases. So first, when speaking about family and Supreme Court, it's important, if litigants are interested in doing so, to include cybersexual abuse in their family offense petitions and also potentially in petitions for custody or visitation where it may be applicable. And in fact, one of the resources that we included as a part of this presentation is quite a comprehensive manual, our cybersexual abuse manual, which we issued in May of this year. And it includes not only some sample family offense petitions in the appendix, it also includes some sample orders of protection with the language that can be asked for and the provisions that we typically ask for, although I encourage everyone to really think about the individual facts of the case because we've had orders of protection, which I'll talk about the typical language we use, but you can also get language really under the Family Court Act addressing a number of behaviors, whether it's impersonation or kind of harassment offline or if it's the sending of images. So it's something that certainly we have increasingly brought up, and at least where we practice in the New York City family courts, but given the new local laws also in other city courts and now the new state law, where we'll talk about in a second, there's a new family offenses in place. It's definitely something that you should consider bringing up in your cases. So you can add language to address it in orders of protection, orders of custody or visitation, or even just bring it up on the record. I've often had judges who will just admonish the parties if that's happening for, no images to be shared or that's not appropriate, or if folks try to bring it up, the opposing parties will try to bring it up as kind of proof of clients. Again, going back to the power and control dynamics of showing, this person is slutty or they're not a good parent because they're posting these images or they're getting fired from their jobs for having sex. Call it out for what it is, which is a form of abuse. For criminal court, as Nicole mentioned, there are ways to address cybersexual abuse under the new criminal penal law, which Nicole addressed in detail, as well as the local laws that potentially apply, as well as the other penal codes which might apply. So unlawful surveillance, which Nicole mentioned, actually used to be termed as New York's kind of anti-quote-unquote revenge porn law. It specifically refers to videotaping in very specific locations without the person's knowledge or consent. So there's individual intent requirements and location requirements, things like engaging in in undressing in like a dressing room or a hotel or a bathroom. So that's really kind of almost like not even a peeping Tom law, but just an unlawful. It's recording someone without their consent. So if, in fact, the video or image was created without your client's knowledge or consent, perhaps unlawful surveillance would be applicable. And, of course, the state law, which Nicole mentioned, as she stated, the consent is about the time of the posting or the disseminating. It does not matter if the photo or image was taken with your client's consent. And, in fact, that's kind of part of the victim-blaming mentality that we often see that judges or law enforcement or just, frankly, society finds that it's not defensible for clients if they have taken a selfie or a video of themselves for then, okay, well, that it's your own fault, essentially, because you took a photo of it. That is not what the law says, and that is a very damaging and problematic assumption that we are working as advocates to kind of counteract. So just a reminder on that point. And I'm also going to address harassment and coercion in a couple of slides as well. Criminal courts can also add language to address cybersexual abuse and orders of protection. And increasingly, I think at a slightly slower rate than family courts, but we have certainly seen criminal court orders of protection addressing this type of behavior, particularly when the crimes are being charged are directly the cybersexual abuse crimes. So with the advent of the city law, we've seen increasingly criminal court orders of protection with non-dissemination provisions. I would encourage any of you, if you have clients whose abusers or who folks are being arrested for these crimes, to advocate with the district attorneys and speak with them and include the sample language and ask for it to be included, because it's not going to be included unless we continue to advocate for it and get it included, which I'll talk about the language in a second. The new state law, as Nicole mentioned, we're very excited that it's created a new family offense of unlawful dissemination or publication of an intimate image. So really great for those of us who practice in family court, really great for clients who may not be interested in pursuing criminal charges or who perhaps want to do it concurrently with a family court case. And in fact, we often find that in family court, we're able to get orders of protection with non-dissemination language. And then ultimately, if the abuser violates that, then perhaps it then becomes criminal contempt. It's a violation of a court order. And so now it's preventing abusers even further from disseminating this kind of language. So it has the same elements as the criminal law, which Nicole mentioned earlier. So important in pleading in a family offense petition to simply identify the facts that would create the crime of unlawful dissemination, the intent, the not lack of consent, what the video or picture actually depicts, and then the effect on the victim, always important to include as well. Just a couple notes on the family court authority to address cybersexual abuse. This is something that we anticipate will be less of a problem now that cybersexual abuse is a particular family offense. Now it's been recognized as a form of gender-based violence, as something that the family court has explicit jurisdiction over. But in case you have judges that are not as familiar, again, it's brand new, just this past weekend. So there, I imagine, will be judges who are not familiar with it, who are not familiar with what it means. And so utilizing, just noting that family court authority to address cybersexual abuse and other forms of abuse, as those of us who practice in family court are aware, has authority under 842K to impose reasonable conditions, observe other conditions as are necessary to further the purposes of protection. So this is exactly where one could argue to the court that an order ordering respondent not to disseminate any naked images of the petitioner would certainly be necessary to further the purposes of that petitioner's protection when part of their abuse is the abuser creating or sending naked images of them. So I think the Miriam M case is always a great site whenever we're talking about kind of using the court's equitable powers pursuant to 842K, and just really argue that the court has, in fact, in the past, and other courts have done this, and utilized this provision. And again, the manual that we provided as part of the materials for today also includes a memorandum in the appendix that argues all of the family court authority to include orders of protection and impose conditions relevant to cybersexual abuse. So please feel free to print that out, bring it to court. That's what I often do whenever I'm arguing in front of judges who are not familiar with this form of abuse. Again, because cybersexual abuse is a specific family offense now, it may not be as necessary to kind of plead around it as we have been in the past. But I am going to talk about a couple of other ones because there may be circumstances in which the cybersexual abuse or the cyber abuse that your client is suffering may not meet all the elements of the new family offense, in which case perhaps it might be necessary to plead it under an alternative family offense or even a crime. Again, those of us who have practiced in family court know that family offenses are imported from the criminal penal law. So the elements are the same with very minor exception. And so if you can argue that it's a family offense, you may even be able to have someone, if the client is interested and if the client wants to pursue criminal charges, to make a report and have it be pursued under one or more of these penal code charges. So harassment is one that those of us in family court are very familiar with. It encompasses kind of a broad area of behavior. Harassment, of course, intent to harass, annoy, or alarm another person, where the person engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy such other person and serve no legitimate purpose. So this, again, is a course of conduct type of offense, so it will really be applicable where the abuser has repeatedly threatened or repeatedly in some way engaged in a course of conduct in disseminating or actually disseminated or threatened to disseminate images, videos, or media, or something to that effect. Perhaps if it has not actually been disseminated, this might be a good way of saying, the abuser has threatened to disseminate. You're not going to be able to meet the family offense criteria because there has not been any actual dissemination, but under the threats, if it's a course of conduct, you could potentially get it under harassment in the second degree. Another one we often see is coercion in the second degree, which is kind of a long, I won't read through the entire section, but essentially when someone is compelled to engage in conduct which they have a legal right to abstain from, or to abstain from conduct which they have a legal right to engage in. So if you, file for custody or try to get an order of protection against me, then I'm going to post your naked photos all over your, I'm going to send it to your professor and I'm going to get you kicked out of school. Or if you don't get back together with me, then I'm going to send this naked video to your mom or I'm going to show it to our kids. So arguably, the act, really right now, absolutely, the act of sending a naked photo without someone's consent is a crime. So this falls under Section 3 of coercion in the second degree because the person is threatening to engage in conduct constituting a crime if the victim does not comply with what they're, kind of forcing them to do. And same thing, it could potentially be under these other sections, something that doesn't materially benefit the actor, but which is calculated to harm the victim as well. We often see in the course of domestic violence, of intimate partner violence, coercion is a really common act of threatening to do someone or intimidation. It's on the power and control wheel, and we see it really often. So these are areas under, again, the family offenses or also under the criminal penal law, which may be applicable and may, if you cannot fit under the elements of the new state law or your local laws. So the language that we asked for in orders of protection is this specific language, which again is included in the manual. It's included in the sample petition at the end of the manual. It's included in the temporary order and final orders of protection. The respondent is not to post or transmit or cause a third party to post or transmit any images, pictures, video, or other media depicting petitioner in a naked state or participating in a sexual act or threaten to do the same. Quite a mouthful, but we have kind of added and modified to it over the years because we think this kind of encompasses a lot of the types of abuse that we see specifically around disseminating of images. And again, if there are other forms of abuse that are happening in your case, we have also seen family courts enter non-impersonation, that the respondent's not to impersonate the petitioner online or, go into their social media accounts. So be creative and be flexible, because the family court does have authority under 842K, 842C, other provisions to enter these kinds of equitable orders. It's important to really adapt it to the facts of your case. But this is a really good kind of blanket language that I will often give to petitioners who have this happening in their cases. And often judges have been amenable, and in fact, we've seen them increasingly include this as a part of orders of protection in family court, and also criminal court as well. So just a note on screening for cases, to kind of shift into screening for cases, preserving evidence, and some of the other important notes that we wanted to hit before we move into questions. It's important to proactively ask clients whether the abuser has naked images, has intimate images of your client. And sometimes the answer is yes, sometimes the answer is no, but it's good to know, because if the answer is yes, it's important to know, has the abuser ever threatened to disclose these images? Has the abuser actually disclosed these images? And if yes to either one of those, then it might be something important to include in the family offense petition, and to kind of put the court on notice that this is something that's happening as a part of domestic violence in the relationship. Also important to note, even if the abuser has not actually disclosed images or threatened to disclose images, or even if they don't have the images, that maybe they haven't taken them, or maybe the survivor never sent them, if the abuser has access to the survivor's phone, computer, social media accounts, or other technology, many clients will have photos on their phones, saved perhaps in private folders, and it's really not difficult for abusers to, once they've broken in, to find those things. And in fact, I can think of multiple cases, even recent cases, where abusers have broken into my clients' phones and downloaded these pictures and then sent them. So even if the client does not think that the abuser has images, it's important to do some additional safety planning around social media and tech abuse as well. Also, one note, if clients have ever sent a video or FaceTimed or Snapchat videoed or anything like that, important to remember that the abuser, it's really easy to screenshot that. So if there's any time where they've done a FaceTime and taken off any of their clothing, then there may in fact be images out there they may not even have thought of. That's something that happened in one of my recent cases, and had a lot of pictures that came from that. So really important to remember that as well. So remember to discuss the client's options, of course, around safety planning. Just one quick plug for the Family Justice Centers for those of us in New York City, that there are tech safety screenings available there, where Cornell Tech will actually go through a client's phone and see if there is any spyware on the phone, which is a really incredible thing that's available for those of us in New York City. But there's also safety planning available and guides available. We have some references in our manual, and if you just kind of search around for tech safety planning, that's something that a lot of organizations' information is offered. And of course, clients can report to law enforcement in addition to, in conjunction with, or instead of family court remedies as well, which we discussed earlier.
I think, Amy, did you want to do the CLE?
Yes, thank you. So Lindsay and Nicole have shared a lot of incredible information. So I just want to remind listeners that if you have any questions, we'll be taking those at the end. And you can simply ask your question in the question tab, and we will be addressing them shortly. Additionally, the handouts are available. Under the handout tab, there are 4. And this is particularly important for folks who would like to get CLE for today's program. The CLE affirmation form is available there for download. And I'm now going to give everybody the CLE code for today, which is 3241. So the CLE code is 3241. All right.
Great, thanks.
Thank you.
So we did want to also just talk a little bit about preserving evidence, because it can be really important in these cases. So, online evidence can really be fleeting, especially because it's often, understandably so, the victim's first notion is delete everything, contact the website, and try to get it off immediately. Or maybe, comments to a post, people can, the posters can delete those comments. So preserving evidence as early as possible, we think is important. You can do this by taking screenshots or by PDFing pages. You want to make sure you capture as much as you can, really. So capture images of every place that the photo or video was posted. Capture the comments to the images as well, because the comments could help to show the harm caused. Also, sometimes the abuser will pop up in the comments, right? Responding to other comments to continue to disparage your client, and so that can be helpful in showing intent to cause harm. And so capture the comments. And of course, always try to capture as much as you can. So the whole page, the URL, the date and timestamp if possible. You also actually want to PDF the page of search results. I don't know, I have a little example there, but it's different. I would PDF, not screenshot. Actually, on this example, you can't really see it that well, but when you PDF the search results, you actually do automatically get a timestamp, a date, and the URL on the PDF. And then, of course, if there's been any communications related to the abuse, including any threats to post, you want to preserve that and make sure that you're preserving the continuity of the message exchanges. And that just means if screenshot, the last message of screenshot number 1 should be the first message of screenshot number 2. Again, clients' instincts are to block people on social media, and that's totally understandable. But once they're blocked, a lot of social media and messaging sites will no longer give you access to the history of direct messages with that person. So before anyone blocks anyone, they should capture all of the messaging. And then, of course, you need to discuss a safe place to keep these images. Really, it's a safe place where the client is certain the abuser doesn't have access to, and sometimes that may just be a USB drive, which, we now are keeping more of those around our office, and I think, it's good to have a couple of those handy too for the collecting evidence. Let's see. Oh, there we go. So yeah, so this, I'm going to talk briefly about getting content taken down in a manner that's sort of outside going into court and engaging in the legal process. But again, I think we just want to note, once it's down, right? And so, social media apps, like things like Facebook, they're not really responding to civil subpoenas to dig into deleted messages or deleted history. And so, make sure you preserve the evidence before you start requesting that it gets taken down. Most social media sites, websites, Pornhub, things like that, they have places where you can contact them directly. A lot of those sites now have policies and, policies of use, and those policies of use indicate that quote-unquote revenge porn will not be tolerated and, should be taken down. So you can report content that violates the site's terms and policies, ask that it be taken down. There's often now a direct way to make that report from the website. So this is one example. This is from Facebook. Any picture, there's the little ... up in the upper right-hand side. If you just right-click, you'll see you have some options: find support or report post. And then if you click report post, you get the image that you see on the right-hand side, where you can select the issue, nudity, harassment, etc., and you would pick as many as possible. So, sometimes websites, social media sites, etc., will respond, maybe not promptly, and so your client may need to follow up many times. And I say your client because I think, at least in the first instance, I think that it's helpful for the client to make the actual request. Of course, you can help with, drafting the request, drafting the complaint, etc., to the website. But I think it's helpful if it comes from the client first. I mean, ultimately, an advocate may need to get involved if the website refuses to respond, and certainly there are some that never respond. Grindr is an example of one that's currently in litigation because it did not respond to hundreds of reports and ultimately caused a lot of harm to the individual. So what do you do to help your clients if the website does not respond? Well, there's the possibility of a takedown letter. So if the image is subject to copyright laws, You can draft a takedown letter to send to the website. An image might be subject to copyright laws if your client participated in the creation of the image. So sort of a very clear example is if the client took a selfie with their phone. But there are other examples of where this might apply if the client was participated in the creation of the image. Some websites, so this is YouTube. This is a screenshot I took from the YouTube page. Some websites actually have a direct link where it says submit a copyright takedown notice, and you can just submit it there. And so that's another option. And then, of course, there's injunctive relief against the website under this new law that we talked about earlier, the state law. And I just say questionable because, again, this is the first of its type in the country. There are some challenges, including some, the Federal Communications Decency Act. So, I think that probably the best thing to do to really help your client get these taken down as quickly as possible is to just go with the website, go as many times as you have to communicate with them, harass them, follow up with them on behalf of your client, and use the sort of injunctive relief as, a sort of last resort. So I'm going to turn it back to Lindsay for safety.
Just a couple of safety planning tips. It's important to make sure that the client's phone, laptop, and other devices have passcodes. And if the client has been residing together with an abusive partner, to make sure to change all of those passcodes as well as any passwords and answers to security questions on accounts, because it's incredibly easy once someone has accessed someone else's device, especially if they live together or, in an age of social media, it's very common for partners to share passwords or codes or be able to log into each other's accounts in some ways. So really important to make sure that those are changed after the relationship sours or after they leave the relationship. It's also a good idea to create, secure, unique passwords that cannot be guessed by the abuser, and also give, answers to security questions. They don't have to answer the truth to the security question, right? So if the client's security question is, what was the name of your first dog? And the first dog's name was Bo. You don't have to put Bo, right? And folks, just as long as you remember what the security question answer is, because oftentimes the security questions are very easily guessable by an abuser if it's asking about a mother's maiden name or, the last four of social security number or something like that. So really important safety planning after the relationship ends. Using different passwords for different social media accounts. I know that all of us often use the same password for many of our accounts, particularly for clients. It can be really damaging because once the abuser gets one password, they get other ones. Using and enabling two-factor authentication wherever possible is critical. And for those of you who are not familiar with two-factor authentication, what it essentially is once I log into my account, if it's from a new device or if it's somewhere that's not familiar, then it will send me a text or an email or kind of verify that it is in fact me some other way. I think that all of us should be using two-factor authentication, but I think it's especially important for clients where abusers are trying to hack into their accounts or get into their accounts. And if they know their password, it's quite easy. Whereas if there's two-factor authentication and they don't have a client's new phone number or information, then they would not be able to get into the account. And doing basic things like firewalls, antivirus, checking for spyware, and also a good idea potentially to have clients do a Google search and set up a Google News alert for their name if they're worried about things being posted online. That also might be a good idea to have those search results go to a family member or a friend or an advocate so that the clients are not, it can be really re-traumatizing and re-victimizing for them to have to wake up every morning and wonder if their name is popping up in Google search. So perhaps that's something where family and friends can also help with that, or advocates.
Yeah, and this is Nicole, I'll just add to that in addition to their name, they may also want to put like their phone number because, sometimes abusers will put personally identifiable information so that people, can harass them. So if there's any of that worry, a name, maybe also a number. Here are some safety planning and resources that we think are really good. I won't go over them. You can check them out for yourself. And of course, though, Lindsay and I, because we're so involved in these issues, are constantly getting, emails with new resources, and we're constantly looking for new resources. So you can always email us as well. But here are some ones that we found that we really like. This is that's the NNEDV resources on tech safety. I think because we are running short and we want to do some questions, This is just a quick slide. So, yeah, do you want to talk about this?
Yeah, just one note that we do have a task force around this issue, and if you're interested, you can contact me, Jessica Morak, whose information is on the screen. You can also email Nicole. But essentially, we're attorneys, advocates, survivor leaders around this issue. And in fact, we have a meeting this afternoon, but we have them every 6 weeks or so, and we do have people calling in from across the state if you're interested in advocacy. We're also planning an upcoming conference, October 24th, which many of you may have seen on the DV News listserv. It's going to be a free conference providing CLE credit around these issues, evidence collection, the interaction with youth, and many other related issues that affect our clients. So with that, I think we can move to some questions.
Great. So I'll just remind folks that the handouts are available during the presentation, so you want to pull the handouts down. We'll be ending here in about 10 minutes. And that please use the questions tab to ask your questions. So we'll launch right into the questions. The first question is, do any of these laws apply to abusers who live in another country, but the client lives in New York State?
So the law, as in any New York State or New York City law, there needs to be some kind of nexus to New York State or New York City. And we've had this question asked before about kind of interstate or inner-city issues. If the victim is located in New York State or New York City, or I guess specifically for this New York State, and experiences the crime here, is victimized here, it would just be as if somebody, hit someone in a car in New York State. Maybe they're a resident of another country or another state. The difficulty there, so the answer is yes, it would absolutely apply. The difficulty there would really be enforcement. Is the other state or other country going to, extradite the person here for a cybersexual abuse crime? I would say likely, very likely not, unless there's something else going on. But we actually have had cases where we've had extradition involving this, this type of abuse, especially if it's like very severe and lengthy. The other thing is, we do run across things like abusers online from other countries harassing, intimidating our clients, and it can be really difficult to track down where they're from. It's very easy to mask your location online. So I think, yes, it would apply, but it just may be difficult to actually get kind of action taken against them. I hope that answers the question.
Yeah. And I know that certainly not in this context, but I know that there are cases that involve other kinds of enumerated family offenses, including where incidences actually occurred in other countries, and then involving New York residents, and in some of those cases, they've actually been actionable in family court when the parties all return. Like, I think that there's the case I'm thinking of, I think they were all on vacation somewhere.
Right, right.
Yeah. So then the second question is, I want to make sure that litigants can allege this family offense based on incidents that occurred prior to the effective date of the legislation. If not, I understand that we could use other family offenses that might apply. So this is really about ex post facto and that sort of thing.
Yeah. For family offenses, 100%, because there is no statute of limitations in under family offenses. There's some case law around, there used to be cases where people were getting cases dismissed because things happened too long ago. That is really not the purpose of the Family Court Act, and we sometimes hear that argument in family court, and it really doesn't hold water because it doesn't matter how long ago these incidents happened. You can still allege them, and of course, many family offenses have been added over the last 10 years. We've added sexual offenses, we've added economic crimes, so you can still allege them even if they happened in the past.
Yeah, and I'd just say that before this state. So even though in New York City we had the city law, the city law didn't amend the Family Court Act. It couldn't. So we've been able to get these the non-disclosure provisions put in family court orders of protection. We've been able to get those for several years. Right. So before this was actually a family offense, and so I would absolutely allege it. And in the manual that you have, it's kind of a huge manual, but there is I think it's an appendix of a memo that Lindsay's program, the Courtroom Advocates Project, put together that puts forth all of the law and authority that allows a family court judge to issue this an order of protection that includes a non-dissemination provision. And that was like, we were handing that out way before this was a family offense and getting that provision put into orders of protection. So I definitely think that the allegations should be in there.
But I do think that people should be prepared for arguments because, at least in some other instances, the laws existed prior to the statute becoming like an enumerated family offense. Like there was a coercion statute and there were subsections. They just weren't enumerated family offenses. But here, it's a creation of an actual statute. So I do think people should be prepared that an abuser might make the argument that because the law itself didn't exist at the time that the incident occurred, that they're not liable, that there's no liability there because it's, yeah.
I think that's a good point. I think that, but at the end of the day, and so I do think you may not ultimately get a finding of, that particular family offense maybe because it's brand new, but I think at the end of the day, what you really want is that provision, right? That non-dissemination provision in the order of protection. That's what you really want. And I think you can, I think you should still be able to get that and argue persuasively based on the allegations that you should get that provision as sort of a larger just catch-all way to protect the client based on the allegations.
Right. And I think as the asker mentioned as well, that this is where when we, just to give I didn't say this before, but my background is I'm in the Courtroom Advocates Project at Sanctuary, which means I pretty much go into court and I assist people filing for family court orders of protection. I draft probably hundreds of family offense petitions a year, and I'm in court pretty much exclusively almost doing orders of protection. And so when we draft our petitions, what we do is draft it in a way that we can hit multiple family offenses, as I'm sure many of you all do when you're doing these kinds of cases. So if you draft a family offense in a way that you may be able to get, the new unlawful dissemination, but you also may be able to get harassment or coercion if you plead the effect on the petitioner or a course of conduct, then I think it is a safer way, as you mentioned. Yeah.
And I would definitely also, as you're making your argument, talk about on the harm is continuing, and I think a continuing harm piece, because I think that there is an emotional, I'm looking at the intents again, and there is, language about, harm to the victim. So, and causing harm to the victim of an emotional, financial, or physical nature, and if you can, I'm sure you'll be able to disseminate. The longer images are out or up, the more intense the harm is going to be. So I do think somebody could and should absolutely make the arguments that those laws apply, and let the court figure it out.
Right.
Okay, we have time for a few more questions. Are there any other questions before we lose our wonderful presenters today? Oh my goodness, 2 questions and 60 people. You did a really good job covering everything, Lindsay and Nicole. I'll just give it another minute.
Well, and Amy, this is Michelle.
While
we're waiting for any additional questions to come in, just a reminder that if you are looking to get CLE credit for attending today's webinar, we did put the verification code into the chat box for you. So complete your affirmation form that you should have downloaded. Fill out the complete form, including your mailing address at the bottom, and email that back to me at mpeterson@empirejustice.org.
And one thing I did want to mention, if you are having a viewing party for today's presentation, please have all attorneys who would like CLE to please complete the attorney affirmation form so that we can ensure that everybody who listened today receives credit. And somebody asked, how do you download the handout, Michelle? Can you tell folks how to grab the handout?
On your control panel, there should be a pane that says handouts. If you don't see that, send me an email and I will email you the materials. Again, my email is mpeterson@empirejustice.org. those
I think we
materials.
also have one more question about criminal court.
Oh, great. Okay. Thank you. So the question is, would criminal court get involved and mandate a website to take down an image?
I don't think so, no. And the piece in the new state law is for civil relief. And I think I can't see a criminal court wanting to get into that big mess. I mean, we've been having trouble just getting them to include the non-dissemination piece in the orders of protection to begin with. But I think separately, I don't know that they could.
Because of the CDA Act. Yeah.
There's no criminal liability really because of the Communications Decency Act, and because of the way the new state law is written, it looks like it should really be in civil court.
So a victim could file in civil court to use that injunctive provision under the state law and ask for it to be taken down, but no. I think the answer is no, unfortunately. We also had a question about registry of abusers.
Yes, I see that. Sort of unrelated, but please feel free to answer.
I imagine that, I'm not sure if the question is specifically about, like cyber sexual abuse abusers, because, we do have a sex offender registry.
Yeah, is this about the sex offender registry?
It's not clear. It just says a registry of abusers. So is this considered a sex offense that would be something that could place somebody on the sex offender registry?
Not that we're aware of.
No,
I don't think that would be a bad idea. I think there's actually some interesting conversations around cybersexual abuse as a form of sexual violence. As we understand it, I don't think it's necessarily covered under, for instance, for cybersexual abuse. I don't think it's covered under a lot of definitions of sexual violence because it is, it's an online form of abuse, and so it doesn't necessarily, it's not in the same way of like a physical form of sexual violence. But we absolutely do term it as a form of sexual violence, I think, and
but it's not. It's at the moment, this would not put someone on the sex offender registry. No, and whether they should or not, I don't know. I think that would be a tough ask. I guess I'm not really answering the question. I'm asking more like the practical reality is I don't know that. I think that'd be a tough ask to have that happen.
Yeah, and I know we're running out of time, but the Family Justice Center, we had a question. Family Justice Center's providers for scan for tech safety. Yes, the organization is called Cornell Tech. And if clients go to the Family Justice Centers, these are New York City, but I think Cornell Tech is trying to expand a little bit. They have an intimate partner violence clinic. They will scan clients' phones for spyware and see if there's any spyware on their phones. So reach out to your local Family Justice Center and try to get that. And also,
Cornell Tech will actually be presenting at the conference on October 24th. If you want to hear a little more about that. And I'll just do another quick plug for Operation Safe Escape. They're not New York City based, so they're not going to do like an in-person tech scan, but they're really, really good. Yeah. If you've got a client who's got someone, an abuser who's very tech savvy and is like really stalking them digitally, they're really good with coming up with solutions.
Yep. And for the conference, you can email us, Nicole or I, directly with questions about that. It is going to be located in New York City at Brooklyn Law on October 24th, and registration information will be going out to the DV News listserv soon.
Terrific, thank you. And for the person who is listening in on the phone, and please email Michelle Peterson if you would like a copy of the materials. It's mpeterson@empirejustice.org. And with that, we'll thank everybody for staying a couple minutes over. Thank you, Lindsay and Nicole, for such a wonderful presentation and for these incredible materials that you shared with people all over New York State. It's been a really terrific webinar. Thank you all, and thank you all for listening in. So with that, we are going to end today's webinar. Thank you.
Thank you, everyone.
Bye-bye.